All right, once again, a warm welcome to today's webinar, Learn Best Practices of Data Protection, organized by SGTech, IMDA, and PDPC. Thank you for taking time out to join us. My name is Christine. I'm from SGTech, and I will be your MC for the day. Just some quick housekeeping before we commence the program proper. This session will be recorded for archival and marketing purposes. SGTech may use some or all of the images or videos in its print publications, digital platform, and marketing channels. Recording will be made available post-webinar on SGTech website. You may send in any questions via the Q&A feature at the bottom of the browser. Today, we have an amazing lineup of speakers. Besides the sharing of the 5 most common types of data breaches and how to guard against them, we will also learn about how the enhanced PDPA can help businesses by unlocking opportunities and future innovation. Without further ado, I'd like to invite Ms. Lynn Boxall, the Chairperson of Data Protection Committee, to address the audience. Lynn, over to you, please.
Thank you, Christine, and a very good afternoon to my fellow SGTech members. For those of you who don't already know me, I'm a lawyer and I worked in private practice for 10 years before going in-house in Melbourne and then moving to Singapore in 2000. Did some more in-house, did a few other things, got called to the Singapore bar. So my only point here is that I'm a local lawyer, I'm a Singapore lawyer, not a foreigner, even though that's what I might look like. I do most of my work in data protection in Singapore. I do a lot of other commercial work, but mostly data protection. And I find that the mention of data protection or the mention of the PDPA often seems to bring groans and complaints and a range of responses. It's too hard, it takes too much time, it's not relevant to what we do, it gets in the way of doing business, and so it goes on. Usually ending with, anyway, it's some legal thing and the lawyers can figure it out. For those of you who follow Formula One racing, you might be familiar with the former world champion Kimi Räikkönen saying to his racing team over the team radio during the race, "Leave me alone, I know what I'm doing," after they told him he needed to go faster. So I hear a lot of talk of, don't talk to me about data protection. I know what I'm doing, which is running my business and trying to make money. And the last thing I need is some additional legal problem. So that reminds me of, 20 years ago when I came to Singapore, I remember that workplace safety and health was seen as something that the worksite foreman needed to worry about. If a ladder looked unsafe, for example, that was the foreman's problem. Everyone else could ignore it. Then the government did a campaign to change the hearts and minds of Singaporeans. They made it clear that all employees have a role to play in workplace safety and health, and that anyone who saw that a ladder looked unsafe, for example, would need to do something about it. They built up a picture around organisations that treat workplace health and safety as an all-of-organisation responsibility, being good corporate citizens, supporting the well-being of their staff and enhancing Singapore's reputation as a good place to do business. So my point is that data protection is no different. For most organisations, and here I'm not including the tech giants, for example, it's not all that hard to get it right, although it does involve some investment of time. I argue that it's time well spent. I talk to business leaders who think they probably won't get caught out on data protection. And if they do, all that happens is they pay a fine and life goes on. What they don't know is that the fine is only the tip of the iceberg. The real penalty when there's an investigation is the time and management disruption that comes with the investigation, and overall the loss of trust and the loss of reputation that can go along with a PDPA enforcement. This week is Privacy Awareness Week in Singapore, so we've got quite a focus on data protection across a number of events. Christine's already mentioned what we're going to be talking about today. Just adding a little bit to that, we're going to hear about the recent amendments that enhance the business friendliness of the PDPA, but they also foreshadow a significant increase in potential fines, so beware. But to me, it still comes down to maintaining the trust of your customers and your business partners, the trust that is indispensable for your business success. You know better than me how hard it is to build trust among your stakeholders. I'm very confident that you don't want to throw it away. So back to you, Christina, let's get going.
Thank you, Lynn. Our first speaker for today is Mr. Siang, an Assistant Director of Data Tech, Policy and Technology at the Infocom Media Development Authority, IMDA. In this role, he handles ICT system reviews for enforcement of the PDPA, as well as develop technology guidance for organizations to facilitate compliance with the PDPA. Over to you, please, Siang.
Thank you, Christine. Let me share my screen. Okay, can you see my screen?
Yep.
Okay, good afternoon, SGTech members. I'm Siang. I would actually like to start off this session by checking if any of you attended the DPO symposium on Monday. Because if you have seen me then back on Monday, actually what I'll be sharing today is largely the same thing, just that I'm given a little bit more time, so I will slow down my pace and I will hope to be able to share a little bit more details. All right, so today I'll be sharing with you some tips on how to guard against common types of data breaches. Sorry. So we are aware that organizations, especially SMEs, have limited resources. And you may be wondering, you may have read our tech guides. Out of all the recommendations given by PDPC in terms of ICT security, which ones are the most crucial and which ones perhaps should you look at first? In fact, perhaps you may be feeling a little bit like this. Right, a bit overwhelmed by all the things that we have mentioned, so many good practices, right? So we felt, we hear you, and from our past data breach cases, we note a clear connection between weak cybersecurity and data breaches. And a few months back, I was actually asking myself, is there any way we can identify the most crucial good practices, and hopefully those can address most of the issues and maybe prevent most of the incidents from happening. Some people call this the Pareto principle or the 80-20 rule, right? So what we have done actually is to analyze our past data breach cases, right, Singapore cases, and we studied them and we asked ourselves, so what are the most common type of breaches we have? What do we really need to, what are the most relevant good practices that could have prevented these breaches, right? And the result is this new handbook, how to guard against common types of data breaches. So I'll bring you through some of the key points. So based on our analysis of past cases, these are the 5 most common types of data breaches, right? I will be explaining to you what each is about. So this is the top category, most common issue. We call it coding issues. It's about mistakes made during the coding phase of software development. And these are, from what we see, the mistakes are usually logical kind of errors, logic errors, right? Unlike things like typos, you know that if you spell a command wrongly, for example, the application wouldn't even be able to compile. You can't build the application, it can't run, right? These are so obvious errors. But logic errors are not so easy to detect by automated means. And let's look at some examples. For example, organization B, they were trying to fix an error in the application. So they developed some new code, but they inserted this new code into the wrong part of the application, right? Resulting in wrong customers' information being retrieved. And organization C, they created a lookup query, but they used the wrong data field for the lookup because there were several data fields that looked very similar. And so the lookup query retrieved incorrect person's record instead of the intended person's. So again, wrong personal data was retrieved. So our recommendations to address these cases are, firstly, design and plan before doing your coding. This includes doing impact analysis, right? Having proper documentation is very important, right? You want your developers to have clear specifications to refer to and not having to make guesses because they do not know and they are not sure. And also your employees, they do not stay with you forever, right? Even sometimes you may have a guru in your team, and let's say this guru, everything is in the head, doesn't write down anything, doesn't document anything. One day the guru is going to leave too, and then when that happens, you'll be in trouble. Thorough testing, there are many different types of testing. What's most important is that the test scenarios are sufficiently comprehensive and they match your real life scenarios that you face. And, and remember that testing is meant to test and not meant to pass. And code review, right? You can call this last but not least over in this screen, because in all the cases that we have seen, actually in this category, actually we felt there was a good chance that a good, well done code review would have a good chance of being able to catch the error and to prevent the incident from happening, right? Of course, it helps if the person doing the code review is an experienced developer. The next category is what we call configuration issues. This is a broad category because there are a lot of different kind of settings everywhere in your IT system. For example, over at your websites, firewalls, folder permissions, and all kinds of software, all kinds of security settings. We also classify source code management and deployment under this category. So for some examples, Organization H, right, during troubleshooting, they temporarily configured a web folder to be publicly accessible. After the problem was resolved, they did not restore the original setting, right? So the web folder was left like permanently publicly accessible, and this led to a data breach. Then we have Organization G. They misconfigured their antivirus software. They specified the wrong URL for the software update to be done. So for a long time, the antivirus software was not updated. So eventually they were infected with malware. So our recommendations for this category are, firstly, you need to harden what they call harden the system configuration, which means to tweak all the settings to be secure, right? A lot of software components will come with default settings. Right? These settings are, of course, meant to maximize the convenience and get you running, get you up to speed as fast as possible, right? In order to do that, usually the settings are not optimally secure, right? They are meant for convenience. And also automate and build your deployment process, right? Use scripts, minimize your manual steps, minimize human error. Document your baseline configuration settings, right? You see the word document here. In the previous section, it was about documenting your code. Over here is documenting your baseline settings and establish procedures for configuration management so that everything is very systematic. All your changes are systematic, all your changes are approved by somebody. And when you have to do troubleshooting, note down the configuration changes made, right? Because usually if you have to change a configuration, there are two outcomes. Right. One would be it doesn't work and you have to revert back the setting. Second one would be it works and you want to continue to use this new setting. So either way, you should be you should note down the configuration changes. And lastly, to conduct a security review to ensure that your current settings tally with your recorded ones, as well as to make sure that they still make sense. The third category is malware and phishing, right? Malware is short for malicious software, right? It's a blanket term for viruses, worms, trojans, and other harmful software. And phishing, and there's also other related kind of phishing like spear phishing, and all that. These are easy ways for threat actor to target humans who are the weakest link. So for the hacker, phishing attempt is just an email that costs them nothing, but it can cause great harm to businesses. You can infect our computers with malware, we can compromise our login credentials, we can lose our personal data. So this is something you really need to be careful. Here are some examples. Organization I, the employee clicked on the malicious link in the phishing email and leading to malware infection of the email software on his computer. So what happened is the malware retrieved emails and sent it out to external parties, and these emails contain personal data. Organization J, their ICT staff left the company, and that person was the person doing the system patching and all that kind of things for the past period. And after he left, all this system patching was not done for 12 months or any kind of security reviews or any kind of checks. So eventually the system was infected by ransomware, and Organization J were locked out of their own personal data. Our recommendations for this category is educate your employees, right? Because they are your weakest links. And to complement this education, right, you can conduct regular phishing simulation exercises, right? This is like the experiential part of the learning, because they get to see the situation happening on them, and how do they react to it, right? Do they apply what they have learned, or they have forgotten about it? And install endpoint security solutions like antivirus, anti-malware. Of course, very importantly, keep them well updated. Consider restricting internet access, right? It is quite common to have blacklisting of known malicious websites. You can also consider going one step further to have whitelisting, which means you only allow certain legitimate websites that are required for your work, for your business. Why is this helpful? Because quite often the phishing email only contains a malicious link, and if the link cannot be reached, you can't reach the malicious website on the other end out in the internet, no harm is done. And lastly, ensure that personal data or other data is regularly backed up. And this is important, especially for ransomware, because it's your only chance to get back your data. We have heard a lot of stories whereby the ransom was paid, but the hackers are gone and they never respond. They never give you back a key to decrypt your data. The fourth category is security or responsibility issues, right? There's better awareness now of incorporating security when developing ICT systems. We call this data protection by design. But what's also important that after the system is developed and rolled out, during system maintenance, right, for the rest of the period, for the years that are to come, somebody is also checking on the security of the system, right? And somebody needs to be assigned the responsibility to do so. Another risk is using production data for system testing in the test environment. This is dangerous because test environments are usually not so well protected. So let's look at some examples. Organization L, they contracted a vendor to implement their online resource booking system. They continue to pay the vendor for system maintenance. However, in the contract, the scope of the work was only, if you report a problem, I will fix it for you. The contract did not specify that the vendor was overall in charge of security and have to keep the system secure. So this system was developed 5-10 years ago, a long time ago. And over time, without any extra effort or maintenance, the system's code became vulnerable, right? And they were affected by new exploits. Organization M, they place a text file containing personal data in the test environment for testing, forgot to remove the file after the testing. So eventually the test server was, the text file was picked up by search engines because it was accessible from the internet. So our recommendations are explicitly assign responsibility in terms of the ICT security. For example, who's to do the patching, who's to check on the log files, etc. Right? Is it in-house somebody or is it your vendor? If it's your vendor, make sure you state it clearly in your contract. Protect your personal data through access control. So by default, web pages and documents on the website are likely to be publicly accessible, right? Because that's what a web server website is meant for. And search engines can find them and can index them. They will be available to anybody. And create synthetic data for development and test purposes. Don't use production data. The last category, accounts and passwords. This is the last of the 5 categories. Sometimes people refer to them as user credentials or login credentials. Right? Passwords are like the keys to your system. They're very useful to hackers. Right? Once the hacker managed to get the password, the system does not care that they are hackers. The system treats them as legitimate users. And if your hacker gets hold of an admin credentials, the system will treat them as a legitimate admin, right? They can access a lot of things. They can access all the personal data you have in the system. So there are a few ways that this can happen. For example, weak passwords, passwords too short, too simple, too easy to guess. And we have brute force attacks. That means the automated guessing of your passwords. So the weaker the password, the easier is it for the hacker to get your password. Default passwords are risky because they are well known. You can easily find published listings of default passwords out there. Credential stuffing means we're using passwords across systems. So what happened is that maybe there's a data breach at one platform, and then the hacker has a whole long list of user credentials, and they'll try their luck at different platforms and different websites, and they hope to get lucky. So for those users who use the same password across different systems, then the hacker will get lucky and they will have your credentials. And digitally writing down your password, so to speak, at somewhere, and that somewhere is not very secure. Then administrative passwords. Yeah, I've talked about this. Okay, these are you need to give even more care to these because they can access more personal data. So some examples. We have organization O, the IT vendor, placed the database login credential in the text file in the env file, which usually contain configuration values. So they placed it somewhere that was unprotected and publicly accessible, and public personal data was exfiltrated from the database. As for organization Q, their EDM software, the administrator password was a simple, easy to guess one. It has not been changed for 10 years, and it was also shared among multiple users. So eventually the admin account was hacked, and then the spam emails were sent to the customers in the EDM system. So the recommendations are to review the user accounts periodically, do your housekeeping, remove accounts that you don't need anymore, right? Try not to have to record down your your passwords in any files. And if you have to, make sure they are well secured, right? Minimize risk of brute force attacks. So remember that if something is internet accessible and you have no measures against brute force attacks, it's only a matter of time before someone is able to brute force and get it, right? If somebody's interested in it. So what can you do about it? You can do like account locking after several X number of failed logins. You can implement CAPTCHA to try to slow down automated logins. And you can implement a delay after every failed login. So adopt and implement a strong password policy. This can mean a longer password, use passphrases, have a password history policy. That means you can't reuse your old passwords. And don't reuse passwords across systems. That one you cannot enforce in the system. You can only educate your users about dangers. And of course, for administrative accounts, have stronger requirements. For example, requiring to have a and actually, well, yeah, one last thing to share. Yeah, if you have systems that are like 5 years old, 10 years old systems, still being used, still online, still containing data, personal data, right? These are likely to contain more vulnerabilities than the brand new system that you roll out now. Because it's based on older technology, it may not be well maintained in terms of security. So make sure you check on those older systems too. Okay, so I've come to the end of the sharing today. You can download our handbook from our website. This is the URL and the QR code, and we put the recommendations into practice. Okay, thank you very much. Okay, back to you, Christine.
Hey, Christine, sorry, I think you muted.
We can't hear you, Christine.
Sorry about that. Okay, thank you, Siang. Next up, we have Mr. Desmond Chow, who is the Director of P2D Solutions Private Limited, the first data protection and PDPA compliance consultancy and advisory service to obtain the Data Protection Trustmark certification. Due to its experience and track record, P2D Solutions has been appointed by IMDA to support industry engagement efforts in raising awareness and promoting compliance of the PDPA. Over to you, Desmond.
Thank you very much, Christine. So let me share my screen now, right? I hope everybody can see that. You can see what's on the screen right now. So today, we're going to talk about how to unlock the value of data and to innovate with the enhanced PDPA. Now, given technology, as you all probably well know, right? There have been technological advancements in our times, especially in the last couple of years, simply because of advances and things like that. So with this, there is an increasing shift towards digitalization, and it has changed essentially how organizations operate and do business as a whole. Now, with accelerating growth of data growth in the data-centric technology such as Internet of Things, big data analytics, cloud computing, smart nation, AI, so on and so forth, there is an actually exponential increase in the volume of personal data that's being collected, generated, and used. And therefore, this calls for stronger organizational accountability and good data governance. Now, as you can see from the slide, right, the good data governance basically fosters consumers' trust, strengthens data protection and resiliency, and then facilitates use and the innovation of data. Now, as you probably well know, right, the PDPA was passed in Parliament in 2012, right, and basically came into effect 2nd of July 2014. It basically governs the collection, use, and disclosure of personal data by organizations, and in a manner that recognizes both the rights of individuals to protect their personal data, in other words, to protect their privacy, right, and the needs versus the needs of organizations to collect, use, or disclose personal data for reasonable business purposes, right? So this PDPA Act back when it was passed was basically to set a baseline law in place governing how organizations collect and use personal data, right? And through that, demonstrate good organizational accountability and good data governance as well, right? So in order to adapt or to update itself with the fast-changing landscape of Singapore's digital economy, right? The PDPA in on the 2nd of November 2020, right, Parliament passed a Personal Data Protection Amendment Act 2020, right? And this further strengthens the consumer's autonomy and supports businesses to use and harness data more confidently, right? So this is a pictorial, more pictorial flowchart form, right? This is how companies collect and use personal data. Collection usually takes place in the form of online forms, maybe hard copy forms in certain cases of customer information, enrollment forms, job application forms, employee records, membership forms, can be many other different types of personal data that are collected, right? Upon collection, what the company then does is either use the personal data or process the personal data, for various transactions, for various purposes, such as payment services to facilitate and manage, and membership administration and manage and loyalty programs, right? For publicity and marketing, as well as for audits and stuff like that. There may be further disclosures to other subsidiaries in the group company, to other to HQ or parent company level companies, as well as other vendors and partners, if the further processing takes place as well, right? So, touching on the data protection provisions, right? As you well know already, the PDPA, since it was passed, since it came into effect, is basically a data protection regime that's technology neutral, principles based, right? And complaints based, which basically means to say that generally the PDPC will not conduct audits or on the company's compliance, but is based on complaints or feedback received by the PDPC itself, right? Originally, there were 9 obligations to this, but with the Act amendment that was just passed, there are now a total of 11 obligations, and the 2 new obligations, as seen in the slide, are the data breach notification and data portability. Now, the obligations now are split into 3 basic broad phases of the data lifecycle, right? And the overarching obligation is obviously accountability, which is entrenched within the data management lifecycle. So basically, for those of you who are not sure, all right, accountability refers to a risk-based approach to identify, monitor, and then respond to data risks, right, throughout the data lifecycle, right? And its importance is heightened when we rename, back in 2019, right? The PDPC basically renamed one of the old obligation from openness to accountability, right? And this basically was done to try and move all organizations from seeing PDPA the PDPA as something simply a checklist, a checkbox kind of compliance, to a state where being responsible for personal data and how you discharge this responsibility, ultimately is under your organization's possession. So there are 3 broad categories. One is for the collection of personal data, and that includes notification, consent, and purpose limitation, right? The green phase, right, which comes under the care of personal data, and the obligations under the care of personal data would include accuracy, protection, retention limitations, and transfer limitation, right? And the last one, the last phase would be the orange, right, which is the individual's autonomy over personal data, right? And this last set of obligations relate to the interaction and communication with individuals in response to their rights and control of their personal data under the PDPA, right? So we will talk more about this data breach notification a little bit later on. The data portability obligation is not in effect yet. It will probably be rolled out later part of this year, but that's a story for another day, right? What we want to talk about right now is that there are some situations, some situations whereby these are some exceptions to, not needing to get consent when collecting personal data. This is responding to an emergency, managing or terminating an employment relationship, evaluative purposes, or if the personal data is publicly available, right? So please note that, if you're going to use any of these exceptions, that and in this case, volunteers are seen or considered to be employees of an organization for all intensive purposes, right? And employment does include working under an unpaid volunteer work relationship, right? So there is an enhanced framework for collection to support data use, right? There are basically more purposes recognized under the PDPA, right? For new exceptions. Under business improvement, legitimate and illegitimate interest, some of the existing exceptions has been revised or expanded as well, such as for business transactions, business asset transactions, as well as for research and development. There are also the deemed consent, right, has also been broadened, right, to include deemed consent by contractual performance and deemed consent by notification, right? Please note that this enhanced framework will not be applicable for the sending of direct marketing messages, right? And that deemed consent by notification, the organizations have to conduct a mandated risk assessment, which is available by PDPC. So these new exceptions, right, to cater to situations whereby there are larger public or systemic benefits from obtaining the individual's personal data is not appropriate, right? For business improvement, you can use personal data without consent for enhancing goods and or services, right? Improving operational efficiencies, understanding customers to offer personalized services. An example of which would be credit card companies deriving insights on existing customers' spending habits to develop a new line of credit cards or reward schemes, for example. There are certain conditions that need to be met, for example, and these only and for business improvement, it has to be for existing or prospective clients only. It has to be a situation whereby a reasonable person would consider appropriate under the circumstances, and for sharing of personal data within an organization or between different entities of the same group of companies only, right? So when we talk about legitimate interest, right? In that sense, companies are now able to collect, use, and disclose personal data without consent for lawful interests of organization or for a segment of the public. For example, a group of hotels, right, getting together to compile and share a blacklist of hotel skippers, which are people basically who don't pay their hotel bills before they leave. In this case, there are also a set of conditions they need to meet in order to use this exception. One is to conduct assessments and a balancing test, which I mentioned earlier, a mandated risk assessment that's available on by the PDPC, right? It's a website. Articulate to individuals what these benefits are, whether they are real and present, right? Disclose that the organization is relying on this exception, for example, through its data protection policies, and then provide the business contact information of the person or persons whom customers can get in touch with if they have any related questions, right? Now for the revised exceptions, when we talk about business asset transactions, basically organizations now can collect, use, and disclose personal data without consent, right? It's no longer limited to the sale of assets, but expanded to include more activities under business asset transactions as well, including mergers and acquisitions, sale of shares, transfers of controlling interest of power of interest, right? Corporate restructurings and corporate and reorganizations, right? Changes to the research and development exception is to improve or expanded to enable organizations to use data and conduct broader R&D that may not have immediate applications to their products and services. For example, labs to carry out expanded R&D, for example, research consultants to do market research or studies, or to disclosure of data for historical or statistical research, right? Under broadened deemed consent, right? There are now there's additional deemed consent by contractual performance, right? This is basically to allowing organizations to disclose personal data, right? Recognizing multiple layers of outsourcing to facilitate data sharing, right? For example, right? In order to facilitate or to execute or to meet certain contractual obligations, right? For example, in this case, an online retailer disclosing customers' personal data to their logistics partner in order for order fulfillment, right? Therefore, this ensures smoother and faster service delivery to the customers as well. Now, the other one that's mentioned here is the deemed consent by notification. And this basically allows organizations to use and disclose personal data, right, for secondary purposes. And in this case, whereby the organization is unable to rely on any existing exceptions. For example, hotel sharing members' preferences and reviews with travel websites to develop travel packages, right? For the deemed consent by notification, there are certain conditions attached to it. One, then organizations, before they share the data or use the data, need to conduct a risk assessment to eliminate or mitigate any adverse effects on the individuals, right? There has to be adequate notification with a reasonable opt-out period, right? And in this case, the individual can still, you have to have provisions whereby the individuals can still withdraw their consent at any time for that. Right, so moving on to the DNC rules, right? As part of the PDPA amendment bill, right? The PDPA's DNC provisions and the SCA's spam control provisions both aim to address, consumers' annoyance and provide consumers with greater control over unsolicited marketing emails or messages that they may receive, right? So in this case, the opportunity was taken to review both pieces of legislation to rationalize the requirements across communication channels today. And basically, right now, as part of the alignment, right, there is a prohibition on the use of dictionary attacks and address harvesting software to be used under the SCA has been introduced under the DNC as well in respect of sending specified messages to telephone numbers, right? So this slide basically demonstrates what is a specified message and what is not a specified message. A specified message is basically a message offering business or investment opportunities, whereas a non-specified message is sent solely to promote, for example, in this case, an employment opportunity, right? So sorry, yes. So moving back as well, right? Under the DNC, so withdrawing consent under the DNC now, instead of 30 days, which was 30 days previously, is now to be completed in 21 days, as well as the validity of the DNC registry checks will be down from 30 days to 21 days as well. After which the organization, right, is required to check the DNC registry again before sending a specified message to a Singapore telephone number, right? So for the scope of organizations covered under the PDPA, right? So as you all know, all private organizations with data activities will have to comply with the PDPA, right? In addition to any relevant sectorial legislations where applicable. In this case, data intermediaries who are the outsourced partners of organizations to process personal data on behalf of such organizations will be also required to comply with the PDPA, except that data intermediaries need only comply with a reduced number of obligations, namely the protection, retention limitation, and data breach notification, right? It is important, right, for organizations to be able to distinguish between what are data intermediaries and what are normal vendors, right? I would like to say that not all vendors in this case are data intermediaries, because only vendors that process personal data, right, on behalf of their customers are considered data intermediaries. And this makes a difference in how they're treated in the eyes of the PDPA, right? So there is the only part that's new about this, the scope of organizations covered under PDPA is that private organizations or agents processing personal data on behalf of public agencies, right, will now similarly be required to comply with the PDPA as well, whereas in the past they didn't need to. Public agencies are subject to the Public Sector Governance Act, the PSGA, which is similar to the PDPA, if not more stringent in certain areas, right? So for public agencies who conduct telemarketing activities, the DNC will apply, right? So there is now a shift towards accountability in data governance as well, right? So and as I mentioned earlier, right, there was a previously, you can say, I mean, you can tell that when they replaced one of the previous obligations of openness with accountability, what the PDPC was trying to do was to move organizations away from viewing the PDPA as a checkbox compliance, right, where organizations just undertake and demonstrate responsibility to the personal data they collect, right? But doing it towards accountability, whereby they try and build public trust in order to thrive in this new data-centric landscape. So basically, you know, accountability. So in order to do that, they have actually tried to publish many guides and frameworks to help organizations make this journey, carry out this journey, right? So there are guides and frameworks that were published, such as the PDPA assessment toolkit for organizations to assess an organization's PDPA compliance readiness, or right, a guide to developing a DPMP, which is a data protection management program, right? Guide to DPIAs, which is the data protection impact assessments on how to assess risk in your organization, right? The guide to data protection by design, trusted data sharing frameworks, and especially the guide to accountability, right? Furthermore, in 2019, IMDA IMDA and PDPC both launched the Data Protection Trustmark certification scheme. This is basically an enterprise-wide certification on an organization's standard of data protection policies, processes, and accountability practices, as well as the APEX CBPR and PRP, which is specific personal data, which relates to specific personal data or systems, or specific offerings or types of processing services involving cross-border data flows. Now, and now with this, right, which just came into effect the 1st of February 2021, right, the enhanced PDPA, right, aims to strengthen the organizational accountability towards management of data, and it seeks to also further, as I said, one of the goals is to facilitate innovative use of data as well and provide greater consumer autonomy, right? So to achieve accountability through the DPMP, right? For more details on this, you can refer to the guide on accountability, right? On what is a DPMP. So broadly speaking, a DPMP is short form for Data Protection Management Program, right? Basically, it is a systemic framework, right, to help organizations establish a robust data protection infrastructure, right, in which it begins from top down, from the organization's leadership all the way until down senior management all the way downwards as well. So there are basically three P's, right? Policies, people, and processes. So policies, basically, your senior management need to embed data protection as part of corporate governance frameworks and establish, you know, a proper reporting mechanism as well, right? People, you need to embed data protection training and development throughout the employment journey for all staff across roles, functions, and hierarchies. 3, processes, right? You need to operationalize data protection policies throughout the data lifecycle, and after implementation, be able to review and to update these processes as necessary with regulatory and technological development. So in and of itself, this is something that you know, it's going to be very, very grows with the organization, basically, right? So the DPO competency framework, this framework basically has been rolled out by the PDPC in order to help organizations, data protection officers, right, continue to upgrade their skills, right? So under there's two sections, basically there are 6 under the data protection category, which is data protection management, business risk management, cyber and data breach incident management, stakeholder management, adult audit and compliance, and data governance, right? Whereas data innovation sees 3 areas that DPOs would need to work on, which is data ethics, data sharing, and data thinking practice, right? So in order to, and further details of these trainings and courses for each competency can be found on PDPC's website, right? So what are the new So basically, as companies digitalize, right, greater amounts of personal data will be used, collected, and disclosed, right? Therefore, there is a higher risk of companies having data breaches. And as such, data breaches have gained widespread recognition as one of the most costly security failures, if not through financial impact, as it was mentioned earlier, but also through the company's reputation and loss of consumer trust, right? Therefore, it is crucial for organizations to be well prepared for data breach incidences. With the guide, right, to managing and notifying data breaches under the PDPA, right, the PDPA recommends that a 2-step process. One is to prepare, and the second is to be able to respond, right? Organizations need to have measures in place to monitor and take preemptive actions before data breaches occur, and to formulate and implement a data breach management plan, right? And this response would be in accordance to PDPC's C.A.R.E principles, right? And basically, C.A.R.E meaning C, contain the data breach, A, assess the risk and impact, R, reporting the incident, and E, evaluating data breach responses and taking actions to prevent future data breaches from happening. Now, on the right side, if you look at the slide, right, these are the top 3, causes of data breaches causes of data breaches, which is malicious activities, human error, and computer system errors. So, jump a little bit more detail on the C.A.R.E principles. So C, containing the breach. The first step to do is to act swiftly to contain the data contain the data breach, right? After that is done, move on to A, which is to assess the risk and impact, whereby you need to gather facts and conduct an assessment of the data breach to understand what risk was posed by the data breach and how the risk can be addressed. This assessment should be carried out within 30 days from when they first become aware of a data breach. The duty of the organization is to determine and conclude whether the data breach is likely or unlikely to happen again. Rather, it is to result in significant harm to the affected individuals, and if it's a notifiable breach to the regulator. So reporting the breach, right? It has now become mandatory to report the data breach, to notify the PDPC, right? As soon as practicable, no later than 3 calendar days, or if the affected individuals as soon as possible, right? The duty of data intermediaries in this case is to notify the organization or public agency without undue delay from the time it has credible grounds to believe a data breach has been occurred. And data breaches within an organization is not a notifiable breach. Lastly, E, evaluate data breach responses to consider the actions taken and to prevent future data breaches from happening again. So there are certain triggers for notifiable breach to PDPC, including if the breach is likely to result in significant harm to an affected individual, or it is of a significant scale, right? Basically more than 500 people, right? So personal data that's considered likely to result in significant harm would include an individual's full name or national identification number, plus any of the following: medical, financial, insurance, vulnerable persons, any pieces of personal data that fall under those categories. Now, a notification to affected individuals should be done in the case whereby it is likely to result in significant harm to an affected individual. There are exceptions, right, to notifying individuals. Such exceptions include remedial actions was taken by the organization to reduce the risk of significant harm, or when the personal data was already encrypted to a reasonable standard, right? So then the next step is also there's accountability through the Data Protection Trustmark. The aim of the Data Protection Trustmark, or DPTM, right, is to establish and recognize robust data governance standards to help businesses increase their competitive advantage and build trust with clients, right? So basically, the DPTMs help strengthen compliance and encourage accountability, right? Provide competitive advantages for businesses, boost consumers' confidence in organizations' management of personal data, enhance and promote consistency in data protection standards across sectors, right? And the DPTM was basically developed based on Singapore's PDPA and other international benchmarks. It is an enterprise-wide certification valid for 3 years, and it's a validation of an organization's data protection policies, processes, and practices. So the overview of the DPTM certification requirements include governance and transparency, management of personal data, care of personal data, individuals' rights, right? The benefits to organizations are that it provides assurance, raises business competitiveness, increases overseas market access, demonstrates accountability to the regulators, and strengthens consumers' trust, right? And you can see on this slide, there are lists of companies, right? They have gone through this DPTM process, and these are some of the comments that they have. So the cost of certifications, right, are just two fees, right? Basically, one is an application fee, all right, of $535 with GST payable to IMDA, right? There is an assessment fee payable to the assessment body, and basically this fee depends on the size of the applicant, the annual turnover, the number of sites, so on and so forth, and which assessment body was engaged. So basically, I think if I'm not wrong, right now there are 5. If you want to find out more about the cost of the assessment, please approach the assessment bodies to get a fee quotation. But to give you a sense of the cost, right, for a typical SME, right, the assessment cost could average anywhere between $5,000 and $6,000, right? So for those of you who are worried about cost, there is an enterprise development grant that you can apply for. The standards adoptions grant that will cover, you know, up to 80% of the DPTM assessment fee and the third-party consultancy fees to get your company ready for this DPTM, right? So this EDG has actually been increased due to as part of the COVID relief from 70 to 80% until 31st March 2022. So as part of the enforcement updates, right, there is an accountability in enforcement. So there are new guides that are out, right, which is the guide on active enforcement. Why was this released? Because the PDPC basically has a two-pronged enforcement approach to recognize and incentivize accountability practices on one hand, and then to deter irresponsible behavior on the other, right? So the two extreme cases, the left and right, right, depict the typical actions for a case of investigation, either to close the case, right, or to launch a full investigation. The one I want to highlight, right, and it's the one to incentivize accountability practices, is the voluntary undertaking and the expedited data breach decision, right? The voluntary undertaking may be given, right, if the organization has an effective remediation plan and is ready to implement it. And this is initiated by the organization in the early stages of the investigation and subject to acceptance on PDPC's description, right? The expedited breach decision, right, basically may be given if an organization makes an upfront admission of liability, right, for breaching the relevant obligations under the PDPA, right? And the nature of the breach is very similar to the precedent cases or, yeah, right. So this is the two new incentivized practices, right? So to deter irresponsible behavior, there are enhanced powers of the PDPC. So under the data protection provisions, right, there are revised financial penalties. The cap has gone up. For organizations, it is now up to $1 million or 10% of annual turnover in Singapore, whichever is higher. For individuals, it can be, and this is new, right, up to $5,000 for or imprisonment not exceeding 2 years, or both, for egregious mishandling of personal data, knowing or reckless unauthorized disclosure of personal data, use of personal data for gain or to cause harm, and the re-identification of anonymized data. For DNC, there is a financial cap of up to $1 million of 5% of the annual turnover in Singapore, whichever is higher, or up to $200,000 for individuals. These higher financial penalty caps will not take effect until 1st of February 2022. So considerations for organizations, right? Getting started. So what you need to do? First, definitely the mandatory requirement is for you to appoint a data protection officer. And then while it's not mandatory, right, the PDPC also strongly encourages all organizations to register your DPO with ACRA-based file, right? And then secondly of all, to take stock and review your organization's personal data inventory and to review the data protection policies that are in place at the moment. There are resources on the enhanced PDPA for organizations that are available. They are the advisory guidelines on enforcement for the data protection provisions, the key concept of the PDPA, and the do not call provisions. These have been updated to reflect the latest PDPA amendment bill. There are other various electronic digital marketing mailers as well as infographics that are available to help you along. On the PDPC's website, right, there are various ways to get more information or to learn more about the PDPA, right? They include industry briefings, the complimentary free e-learning program. There are courses that you can sign up for. There's the data protection starter kit and checklist, the personal data assessment toolkit for organizations. If your organization feels that you need to look for data protection specialists or service providers to help you guys along this journey, there's also a directory for you guys to check out, as well as advisory guidelines and guides, and sample clauses and templates, as well as the data protection notice generator. Now, one of the last things I want to talk about is there's a new initiative launched by IMDA and PDPC, which is the DPAS service, the Data Protection as a Service for SMEs. The aim of it is to help you guys reduce cost, manpower, and to reduce the risk of you guys organizations experiencing a data breach. It is basically a package deal that is a pre-scoped package, right? Basically is two parts, right? One time, including a one-time setup, which will put in place a data protection management program for you guys, for organizations, right? Including data breach management policies, staff training, and communications. And subsequently, after about 1 year later, the service provider will come back again and then provide the annual retainer service, which will include a review of your data protection policies at the point in time, conduct a data breach tabletop exercise, and then provide refresher training for employees. For more information, please check out the web link listed below, right? Find out more about the DPTM here as well, right? Just by scanning the QR code. And if not, you can obviously pick up the call and talk to anybody at the DPTM department to find out more. And I've come to the end of my presentation, right? At this point in time, I would like to say thank you to everybody else. And before we proceed to the next part of to have the panel discussions, right? There is a I'll stop sharing first. There is a poll that we would like SGTech would like you to fill up, right? There are 2 questions. So if you don't mind, I've actually put up the poll already. So take half a minute, wherever else you need to go and fill it up, and then we'll move on to the next part after this. So back to you, Christine. Thank you.
Thank you, Desmond. Okay, so I'll give everyone about 40 to 50 seconds to put in your poll answer.
Christine, I didn't see the poll pop up, but somebody else has just made the same comment.
Okay. Let me double check on that. Songjia, are you able to check on this, please?
Well, okay, so the poll has popped up on my screen, so
Ah,
I
okay.
can see the poll on my screen too. And there are actually 77 responded to the poll.
oh, okay.
Yeah,
That's
out of,
odd.
Okay, so the person who can't see it, there's a couple of people who have said they can't see the poll, so I'm not technical enough to know how to fix that.
right now we have about 76% of the attendees that responded to the poll. So let's just give everyone a little bit more time. So for those who can't see the pop-up of the poll, can you please try clicking on the poll at the bottom? Okay, let's just give the last 10 seconds. We have got 90 responded. Okay, thank you everyone. Okay, moving on to our last segment for the day. Let us welcome all the speakers for the panel discussion. This segment will be moderated by Lynn. Handing the time back to Lynn. Thank you.
Okay, thanks, Christine. We've got quite a few questions here that we'll get onto in a tick, but let me encourage you to ask about those things you want to know. You're not going to get a better opportunity than to quiz our two speakers. I might just, in any event, ask Kai Siang a couple of questions, and that was about the statistics that he shared. So there was, the percentage of each of those top 5 problems. Is that something that the PDPC is going to follow going forward as it changes, or is the top 5 going to, I don't know, change over time, or how's that going to be used?
Okay, can you hear me?
Yeah.
Yeah. So this is probably like the first time we have done such an analysis. And we do not know right now how often the figures are going to have a significant change. But I think we will monitor, and I think perhaps when there is a meaningful change to share with the industry, we will probably do so.
So perhaps I should also be encouraging, I just encourage people to ask questions, but maybe I should be encouraging them to just comment in the Q&A there about the ways that they might use this information in their organisation, because I'm thinking that's good feedback for you, right?
So was there a question for me?
Well, yeah, I'm asking if I ask all of our audience to maybe comment on how they might find that those 5 things useful, that could be feedback for you or for the PDPC.
Yeah, thanks.
Okay, I think over to you, Desmond. There's a couple of questions. There's some hard questions and some easy questions.
Yeah.
What would you like to tackle first?
Well, I mean, let's go from the top down. I think, first come, first serve, right? Okay, so there's a question from Joanna from Perceptive Consulting. Basically saying that they do sign NDAs with clients that allow them to have access to systems or connect via APIs, and they work with different HR accounting platforms across different industries. What other data protection measures can they put in place? Well, in this case, looking at the various advisory guidelines on how to protect personal data would be a good start. There are various advisory guidelines the PDPC has on its website that you guys can, the companies can refer to, right? They do provide a good fundamental, a good foundation on which any organization can build their data protection measures, right? But the thing is, then you have to then be able to look at the different systems being used and understand what is being accessed, how is it being accessed, and if anything else, from a contractual standpoint, needs to be put in place as well. So I think I think that's what I want to say. From a data protection, security measure standpoint, does Siang have anything else that he wants to add?
No, nothing. No. Thanks.
All right.
Yeah,
So
I think I would be saying, you might have covered this, but the guide to data sharing is going to be a pretty pivotal one in this.
That's correct. Yes. Yeah. So there's more than one advisory guidelines that different under, but I think by going through whatever advisory guidelines are on the PDPC's websites, I think that would definitely at least put the organization on the right track, or where to start looking and putting in place security arrangements. For Vivian's question, the next one. Okay, so if organizations do not seek consent from individuals when they collect, use, but have provided an opt-out period for individuals, yes, of course, the individuals can make a complaint to PDPC. So by and large, the PDPA is a consent-driven data protection regulation, right? You need to get consent of the individual. And the best way to get consent is obviously clear and explicit consent, right? So I think I've sufficiently answered that question. Does the PDPC have any guidelines for private organizations that process personal data on behalf of public agencies? Post-amendment, for example, suggested contractual clauses. This is Josephine's question. Yes, I believe, not specifically for processing personal data on behalf of public agencies, but I believe there is an advisory guidelines on the contractual clauses, template contractual clauses, that you should get your, include in contracts with data intermediaries. I think those clauses do and are relevant in this case as well, right? Perhaps look up that specific advisory guidelines. I will try and look for that the web link and answer and give you that particular link a little bit later on once I have gone through the rest of the questions. Now, Vandit has a question that says, can you give some examples of containment measures that organizations should follow? I'm not sure whether I'm the one that should be answering this or should Siang actually. What do you mean by
Yeah, this one popped up just about the same time as you were talking about the C.A.R.E, C.A.R.E. So containment in that context.
I see.
But I think the cover is still Siang.
So containment in terms of data breach, right? So basically you have to, I guess when it comes to a data breach, containing the breach basically means figuring out what happened, and basically if it's still ongoing, then stop it. If need be, turn off the affected workstation or laptop, or if it's a server breach, you may need to air gap, for example, just unplug the servers and make sure you clean up all the viruses and malware that are all there before you power up the server again. Or I mean, it really depends on it's on a situational basis, depending on what data breach, what actually caused the data breach actually.
Yeah, I think it's interesting. I get a lot of panic calls. Oh, we think we've had a data breach. What do we do? What do we do? What do we do? And I say, well, how did it happen? What happened? Oh, but we've got to do something. And I said, yeah. First thing is calm down. The second one is what happened? Because until we know what happened, we don't know how to stop it continuing to happen or what to do about it.
That's right. Yeah. So always look, I mean, yes, obviously, and I think you're absolutely right. The first thing when you figure out there's a data breach, breathe, take a nice deep breath and calm down.
Yep.
Second of all, look at, examine the situation in front of you and decide, and then ask questions about how the data breach arose, what caused it, and then from there you will more or less get an idea of what you need to do after you ask these questions or rather have these questions answered, I think.
Yeah.
Right?
The other thing I noticed when people are having a bit of a panic, and I hope there's not too many bosses on this webinar, that's when the boss helps. When they call me to say, what do I do next? Or if they call you to say, what do I do next? How often is it the boss is on the call to help? And it's not what you need, right?
Well, I mean, that's why, most organizations should have a data breach management plan in place.
That they've practiced.
That takes away a lot of the uncertainty and the panic, and because all you need to do is, data breach. Just remember one thing, and that's to pull out that data breach management plan out from the drawer, dust it off, and then start at step one, right? And that is supposed to, having that ready-made data breach management plan is supposed to prevent some of that chaos, obviously, right? And
okay. I would like to add on maybe in terms of containment for data breach. I think perhaps you can look at the things that you can do in terms of immediate measures that you can do to, like, so-called stop the bleeding. And there will be things that you can do in the longer term to really fix the issue and ensure that it's not going to happen again, right? So I guess containment is more of the front part, to stop the bleeding, to maybe perhaps to disallow access or to stop the immediate issue such that no more further damage can be done. So like what Desmond was saying, perhaps could be something like, disconnecting the affected server from the internet, turning it off, something like that. It really depends on the situation, but to ensure that no further damage can be done.
Yeah.
okay, next one, somebody with the initials TB, I believe. Should the DPO be based in Singapore? Well, I don't think that's a compulsory requirement. It's just that the person that's a DPO should be competent in terms of his knowledge with, on the PDPA, and be able to respond at, provide the necessary guidance and response in cases of data breaches, or if there's a complaint or any access requests and stuff like that, right? So, they have to be able to be manage the various formalized processes that's required, and he's basically fulfilled the role as that's required of a DPO in Singapore, right?
Yeah, and the PDPC has commented on this, although I can't just remember where offhand. They've said all the things that you've said, but they've also said, I think, that the DPO should be contactable by a Singapore phone number, but that doesn't mean to say they have to be in Singapore, and that they need to be generally contactable during business hours in Singapore. So, I would think that if somebody was 2 or 3 time zones away in Sydney, or 2.5 time zones away in Delhi, that probably fits. But if they're sitting in Paris or London, it doesn't.
Well, depends on the hours they keep, I suppose.
Oh, that's true. It's absolutely true.
Yeah, so I mean, yeah, okay. So is there a mandatory requirement to have records of data processing activities? Yes, I think these are called data inventory maps that most organizations need to have in place as a foundation to build their data protection management programs.
Yeah, the records of processing language comes up through the GDPR where they talk about it specifically, but I agree with you. You can't do your DPMP without those records.
Yep.
Yeah.
At least some record of some data flows through the organization at the very least, right? So
yeah, yep.
Is there a category of sensitive data like those mentioned under the data breach notification? Okay, officially speaking, there is no classification of personal data under the PDPA. Everything is, but the PDPC recognizes that certain types of personal data are more sensitive, like it was mentioned, your national identification numbers, financial data, health-related data, data about vulnerable individuals, so on and so forth. Yeah. These are the various types of more sensitive data. Though considering whether or not the data can do significant harm is an important threshold to meet in order to say that this data may be more sensitive and therefore require more security arrangements to be put in place to protect these types of personal data. I understand that there isn't one policy that fits all, but depends on your organization's operations. The data protection policy framework of my organization would be in HR context. They have their directives and SOPs to follow, and in our operational units, they have their own units, directives, and SOPs in accordance to protect. So what you're saying is that, hang on, let me just reread this question again. Okay, so yes, obviously there has to be once you put a data protection management program in place, there should be an overarching comprehensive data protection policy in place. Now, and this guide the direction of how your organization is supposed to protect personal data, right? Now, at a department or division level, right, you should have more specific processes and policies in place, giving more specific instructions on how different types of personal data, in this case, HR personal data, should be protected. So yes, there should be a comprehensive data protection policy in place, but at the department level, you then have formalized processes and more detailed policies on how to specifically protect HR data, right? Hi, panelists. Thank you for I would like to ask how many different methods SWEs could execute to make our IT vendor accountable for the IT work we have engaged in. We have NDA signed in certain general contractual clauses, but we are not sure of how great the details required since different vendors have different scope of work. And there I think in that sense, you have answered your own question, because it really depends on the scope of work that you are engaging an IT vendor to do, right? And ultimately, you also have to think about your own organization and whether you have the necessary IT expertise to handle all the necessary, data protection or IT related, security, to update all the necessary IT security arrangements. If you don't, then you may have to consider amending the vendor scope of work to include that as well. I think if anything else, Siang can probably elaborate slightly better than I can in terms of this IT service providers and stuff like that.
I don't have anything to add for this question.
That's fine.
Yeah.
I
was looking looking at another question by Cui Yu Mok. Where there's unauthorized access of personal data by a malicious actor. Does PDPC view the payment of ransom as a necessary response measure to protect the personal data from disclosure? I don't think we have any formal comments on that. Whether you should, I think really up to your business whether you want to pay the ransom and have a chance to get back. But then, as I've shared earlier during my sharing session, that we have heard quite a lot of cases where the ransom was paid. Unfortunately, nothing was done, right? And the hacker did not provide the decryption key to the organization as they have promised. So really it's a scam. They really just, they did encrypt your data, but they were never intended, I mean, in some cases, they never intended to return you the key.
Yeah, and I'm not a criminal lawyer, but I'd be a bit surprised if paying a ransom is not a criminal offence. Typically is. I think the solution that you mentioned, Siang, of regular backups is the answer really to all of it. I remember hearing a presentation by Singapore Press Holdings probably 2 or 3 years ago now. They back up every 2 hours. I've come across clients where I've said, how often do you back up? And they say every 30 days. And it's like, every 2 hours might not be the right time for your organisation, but I'm very sure every 30 days is not.
Yep. Okay. For data files that contain personnel names and business contact information accessible only to employees, how can we prevent internal employees from misuse of their data for their personal gains and purposes not related to the organization's scope of work? Well, in this case, you know, you can, okay, the only way to prevent employees from doing this is, and I assume that you are doing it already, is by giving them, access controls. You only give those that need access to the personal data to do their work on a regular basis. Assuming you have done this, and assuming that you want to, and perhaps you have really limited the exposure from this angle, then the other way to prevent employees is to basically educate them, provide training, PDPA training on how to protect and use personal data properly and stuff like that, and educate them on the specific data protection policies and processes that your organization has in place, and to say that, look, if you basically are going to be a bad actor and you have bad intentions, right, for the data that we have, you are going to be prosecuted under the law, right, as far as possible, right? So yeah, if they still go ahead and then continue to steal the data, then there's really not much you can do, right, in that sense. You have...
Yeah, there was an enforcement case as well, one of the quite early ones, I forget the name, where the staff used the personal data for our own purposes, and the Commission enforced against her as an organisation and fined her for the amount that was the dishonest gain that she'd achieved.
Correct. I remember that case as well, although I can't remember the name.
Yeah. It's a long time ago now.
Yeah. Yes, that's right. I think this case was the one whereby she was caught selling the data to third parties as well.
That's correct. Yeah, yeah. And the penalty was quite small. It was about $6,000, which was her profit. But they took into account that she was in quite desperate circumstances. So it was quite clear that they would have imposed a bigger fine in other circumstances.
Correct.
Yeah.
So yeah, I mean, in this sense, I think we have probably answered this question as best as we could. I guess I wonder, is there a standard template of questions and workflow for someone to walk through the Q&A and guide them in addressing a data breach? Just like, do you have a backup system for RP, right? Hang on, where's that question gone? Oh, it's
that question just disappeared.
yeah. Well, I think there's a data breach advisory guidelines that we can refer to, right? And that will give some guides on how to respond to a data breach.
There's a question there about ready-made software apps such as WordPress and hosting, and there was an enforcement case on that as well, where the PDPC made it very clear that an organisation that purchases an add-on or anything like that should make really sure that they understand how it works. I forget. Do you remember the name of that case, Desmond? I forget too.
Yeah, it was something to do about them putting a widget on their WordPress website and not understanding that how the widget was supposed to operate, and eventually it led to undisclosed. I mean, it led to a data breach, undisclosed. Unauthorized disclosure of personal data.
Okay, that's right. For that case, actually. It was a case of the company not really understanding what that add-on plugin was supposed to do. So they tried to use it to achieve certain purpose, but actually it was built for slightly different purposes. So there was a misunderstanding of the purpose of the software for that case. But I think in general, what other tips I have about this is also make sure that the software that you're using is still supported by the manufacturer, right? Sometimes there are some, for example, there might be some open source software that are pretty good and popular, but over time, it may be like a one-man show and a one-man maintaining it, and that person becomes too busy in his life to support this product, and it becomes like an unsupported product. The products from the bigger companies, they have an official end of life where they declare that, okay, I'm not going to support this product anymore. I'm not going to release any patches for this product anymore. So I think these are some of the more obvious kind of factors that you should look out for. I would agree that, I mean, if you get a popular, well-known software and they have some coding issues, that you'll be pretty hard for you to be able to detect that, right? I mean, if let's say Microsoft Office today suddenly starts sending out your emails to other people on their own based on a bug that doesn't happen to anybody else, that's pretty hard to expect or to prevent, I would say.
Yeah, but more generally, I think reading the enforcement cases, the PDPC's been pretty unforgiving, and rightly so, in cases where people have said, but I didn't know, but I don't have the expertise. And their common theme has been, you should have found out. You should have hired the expertise if you didn't have it. Not being IT savvy is not an excuse. I don't think there's any people that are not IT savvy on this webinar, by the way, just by the nature of the organisation. But they have been quite plain about that. It's not an excuse. It's not a get out of jail free card. Do you want to tackle the question about mainstream cloud service providers, Desmond? What kind of data protection obligations should we take note of?
Okay. Well, for mainstream cloud service providers, I think it's always important to understand, one, where they are hosting their data. Two, what are the various security arrangements that they have in place. I mean, I guess for my experiences with these cloud service, the normal big service providers, they are able to quite convincingly produce reports that say, yeah, I comply with the PDPA. Typically, if you write to them and ask them how they comply, they would be able to respond. They would typically respond to such requests for data. If you want to understand more, then you should write to the cloud service providers themselves and request for such information, right? And from there, make your own decision, or your and from an organization standpoint, make your own organization's decision whether or not who to go with, or whether to put data on the cloud, whatsoever, and things like that as well, right? I think eventually, since everything is moving towards being put on the cloud, it's just that whether or not you can control certain aspects of it, like is there an option for you to host the data in Singapore rather than overseas or something like that, right? And what are the costs involved? So that is, you have to examine that on a case-by-case basis.
Yeah, the Data Protection Committee, its members include somebody from AWS, somebody from Microsoft. I can't remember if there's somebody from Google, but all of those big companies have got pretty comprehensive documentation online as well. The problem is staying awake while you're reading it, of course, but
yeah,
but it is pretty comprehensive. Yeah.
Yeah, I've seen a couple of the white papers. They're like a couple of 100 pages each or something like that. So yeah.
Yeah, and so that sort of that same answer covers the next question of servers, using Google Drives, for example. Are they in Singapore? Read the documentation, and then, as Desmond said, ask questions if you need to.
Okay. Next question. Understand there's potential risk related to staff working from home. Will PDPC provide a guide on this? Right now, I think there's no specific guide. But whatever it is, your company's existing data protection policies, you should still, whether you work from home or you work from the office, you should still, put in place certain of whatever training that they're giving you, put in place the best practices, right? Clean desk policies, make sure that some of the very more fundamental practices you can actually carry with you to a work from home situation, right? Lock your screen, lock your laptop or desktop when you're leaving, the terminal, even for a few minutes, the kind of thing, to prevent people from accessing it. So a lot of these data protection security arrangements do carry over to a work from home situation as well, right? And the rest of it then depends on whether or not your company's IT department has beefed up its additional security arrangements to make it safer for employees to work from home then, right? So as an employee, then you just need to, in most cases, worry about doing your own part to protect the personal data to minimize that risk, and then the rest of it, then the organization has to then step in and help fill in the gaps in that case.
Yeah. There were stories 14 months ago now. There were stories of people being seen carrying their desktops down Robinson Road so they could work from home. So I hope the IT departments have done a lot better in the last 12 months or so.
Yeah.
There's a couple more questions there. Does the PDPA cover the security of photos and videos on the cloud? I don't know whether that is a question focusing on whether it covers photos and videos, or if it's focusing on covers the cloud.
But generally, I guess if it's a company that collected or is storing the photos and videos, it's an organization that's doing it, then it would come under the purview of the PDPA. If it's an individual, then probably not, regardless of where it's stored, I suppose.
Yeah.
So I guess I don't understand what is the specific question that's there, right? Which part of the security are you worried about? Is it about the cloud security, or is it about
the photos? Yeah.
Photos, yeah.
So we're just about up to time. So pending if we get any clarification on that question, I just wanted to ask you one, Desmond.
Yep.
Do you have any tips for going through the DPTM process, or anything to say about the experience overall?
Okay, well, yeah, so maybe
has it been worth it?
Yeah, I think it was. From our perspective, it was worth it, simply because we learned a lot about I mean, for ourselves, even though we are supposed to be, doing this day in, day out, we did learn a lot from the process. And what I can say is that, make sure that you prepare adequately before even embarking on this DPTM process, right? You shouldn't apply and then realize, oh, I have nothing in place, and then scramble to start getting all the policies ready, the training getting done and stuff like that. So it's always better to realize, okay, so this is more of a long-term kind of goal, right? And you always do know that in order to get ready, you probably want to give yourself maybe 2 to 3 months. I think it's a good time, it's a good gauge to prepare, and then after that, once you're sufficiently prepared, and you think you're ready and your staff is ready to go through the DPTM certification process, then jump right in, right? That process itself, I think most people need to realize that it is not a sprint. It takes time, right? For most companies, it takes upwards of, reasonably 4 to 6 months, but realistically speaking, you can probably say anywhere from 6 months and upwards, right? So it is not something that you should take on lightly. It is not. It is be prepared to work on this over next half a year to 9 months, that kind of thing. And if you're going to be in a situation whereby you have a lot of employee turnover, especially to your data protection officers and your data protection team, then that's only going to add on to how difficult it is to get the certification, because there's transitions, in and out of your organization as well, right? But overall, I say that, look, if you're ready to do it, by all means, I think it's great. I think that, the chance to demonstrate that your organization has a system or has the necessary accountability processes in place to protect personal data, it really does resonate with the clients that you basically do business with, actually. So they do it's increasingly well recognized. So I would think that it is worth considering, right? Especially not just if you are retail facing, but if you are a data intermediary as well, right? And you process personal data on behalf of other organizations.
So thank you for that. And I think I need to hand back to Christine, or I'm going to get into trouble because I've gone over time. If there's a couple of questions there that we haven't answered, I'm not sure if we can get back or what we can do, but we are out of time. Christine?
Thank you, Lynn. Or perhaps we can note down the questions. Song Jie, can you assist? Then we can get back to them separately.
Okay. Okay.
Okay. Thank you, Lynn, Siang, and Desmond, for your sharing. And thank you, everyone, for joining us today. Hope that the session has been insightful for you. And lastly, we'll appreciate your feedback to help us improve future webinars. Please scan the QR code on the screen to complete the survey. I'll leave the slide on for the next 5 minutes. Thank you once again for your time and hope to see you in future events.